welcome to Legally Speaking with me, Tarun Nangia. This is one of our best and most awaited series titled aptly India's Top Litigators. And what a way to start. We have Dr. Abhishek Manu Singhvi joining us, one of India's top litigators. And today he is, in a sense, courting the world's attention because defending somebody like Arvind Kejriwal, people from Washington to London to Germany, United Nations, everybody is watching him. And we are, in a sense, so happy to have him on this show titled India's Top Litigators. He's a regular feature on our series titled Saturdays with Singhvi, where you've seen him speaking on different issues. But today, he will speak on his journey on to becoming India's top litigator, and a formal introduction would be necessary. So I'm sharing it for the benefit of viewers. Dr. Abhishek Singhvi has served as the Additional Solicitor General of India. He is a third-time member of Parliament. He served as an MP 3 times. He also, in a sense, has been holding many parliamentary committees as chairman. Of course, the Parliamentary Committee on Home Affairs also, where he held the charge as chairman. And of course, he is known as a public intellectual. Recently, he was in the United States giving lectures across various universities on an array of subjects. All of this and more today in the show he'll discuss. Welcome to this series titled India's Top Litigators. Good to see you.
Thank you so much, Tarun, for a very generous introduction. Thank you.
At the outset, the whole world would want to know a quick comment first on the Arvind Kejriwal case, because you're defending him, and then we move on to the inception. How do you feel when you defend these figures, when you know the whole world is watching you? What doctors saying, I mean, every single word you utter in court is repeated and re-repeated, not only in Delhi, but across capitals.
Well, one is a professional lawyer, and therefore it's best to not let individual cases get to you. Because the moment you start becoming conscious in litigation, it disrupts your natural flow of thinking and your natural flow of argument. So that's a general principle. But I would be hypocritical in saying that one is not conscious, because I've had the singular privilege of representing almost every major political leader in this country. And by that I mean really almost every major political leader in the country, current and for some time past. That's a privilege. But if you allow it to get to your head, or you allow it to interfere with the weight when you're arguing, then it affects your performance. Arvind Kejriwal is the latest. It is, of course, intimidating when you use words like the ones you used, quite rightly, that the whole world is watching. Elections are ongoing. A Delhi chief minister is larger than life for the simple reason that Delhi is the capital, and it has so many political overtones. But at the end of the day, you always keep telling yourself, this is another case. This is another PMLA interpretation. This is another constitutional interpretation. And it's best to keep it that way when you're talking of litigation. To answer your question very quickly, there are many facets of the case. I don't want to comment on the outcome of sub judice matters, but there are very strong and interesting facets of Section 19, the necessity to arrest you in an 18-month, 2-year-old case, the necessity to arrest you after the first summons is 6 months old, the necessity or the lack of necessity to arrest you when there have been innumerable statements by persons not implicating you. And then suddenly one statement after I arrest that person, which implicates you, and as if that one statement becomes gospel truth. The whole issue of how to interpret 19, which requires a very clear material basis, etc., etc. So these are all interesting. And of course, there is, by the way, a larger issue now here in this case, which happens because of the elections. To keep a level playing field in LPF is the heart of free and fair elections. And the heart of free and fair elections is in turn democracy. And the heart of basic structure is in turn democracy. So in a sense, if you are able to make a supposedly level playing field uneven or non-level, then you are hitting directly at the basic structure. So the interpretive approach of courts must necessarily be in the context that nothing is allowed to be done which renders a violation of a basic structure possible. As you know, the basic structure in India's pride and the world's envy. It, in one sentence, is a remarkable doctrine which says a uh, a uh, a violation, a constitutional amendment which violates basic structure is itself unconstitutional. So imagine the width of the doctrine. So all these and many more are there, but this is true not in one case. In many cases, I'm doing every day of a political nature, and I think it's exciting, it's intimidating, it's unusual, and there's never a dull moment.
Uh, well, but I mentioned Arvind Kejriwal because that's the latest. But if I take the list of names, which will in the due course, it ranges from Namta Banerjee to Uddhav Thackeray to Sharad Pawar to Bhupesh Baghel to DK Shiv Kumar. It's a big list. But let's get to the incident. Yes, you saying something?
I just wanted to say that I am proud of one other thing, and I don't say it with any vanity. I think the names are cross-party, across the political spectrum. And that's what gives me a special privilege. It is across, I'm of course in the Congress. They give me a lot of respect. I hold a senior position in the Congress. But I respect, I like the fact, more than anything else, that across the political spectrum, barring hardly 2, 3, 4, 5 parties, there is not a speck of the political spectrum which I have not represented, and at the top leadership. I think that reposition of confidence in you is something which is very heartening. It heartens you, it enthuses you, and it satisfies you. You know, people think that there is money, fame, running after this, that. It's all there, but they are incidental compared to the satisfaction. There is confidence. There is a feeling of emotion about it. There are feelings of, after all, you know, people who come to us bear their most, closest secrets. It's not easy to do it. And for that, I think I am thankful to God. I'm thankful to all the affection and love reposed in me.
Well, we named political names, but one of the biggest names of corporate India, all of them, I mean, most of them that you have represented, that also we will go through in the course of the show. But at the outset, let's start with the commercial law first. We spoke about the politics at the start. One of the first earliest cases which you really enjoyed and noted and worth mentioning in the commercial side, if you could share with the viewers.
As you know, Tarun, I always say that these are unfair questions because it's like saying, who's your favorite child? But, I understand the necessity of asking these questions because after all, you are doing a kind of a survey of litigation. So having given that caveat, it's very difficult. I've had the privilege of doing a vast number of commercial cases across company law, across IBC, across securities law, across, all forms of commercial law, really. If you were to ask me to choose one, there are so many I could choose, but just to save time, let me give you one example, which I quoted in a book called From the Trenches, which gives kind of 10 or 8 cases, each from a different genre. So the commercial one I could quote would be the one which is about the shareholder democracy, or the Cyrus Mistry and Tata case. Now, that was fascinating because it went from the bottom, the so-called NCLT bottom layer, many, many rounds. It had many facets of oppression, mismanagement. It had initially a long-term facet of the eligibility to sue, 10%, visit 10% of preference shares, 10% of equity shares, a whole host of. And ultimately, it settled in the Supreme Court in terms of the final judgment. But that was one of the more recent and a fascinating and a very hotly contested, high profile, and something of great pragmatic concern to the corporate world and of legal concern. So that cocktail of facets is rare in a commercial case.
So that was Ratan Tata that you were representing.
I was appearing for Ratan Tata and the Tata bunch of companies, a whole host of companies. And it was a major battle because there was a cocktail, as I said, of first and foremost, a very great effect, negative or positive as the case may be, on what is the backbone of the Indian economy. After all, Tatas at the end of the day, from, they love to say, from salt to, whatever, there is not a single area. I always joke with Ratan Tata that when I had some conference or a meeting, you'd get out of the house to sit in a Tata car. You'd go to the airport and sit in a Tata airline. Then you'd get down and you'd again do a Tata discussion of a Tata case. You'd eat Tata salt. You'd probably be staying in a Tata hotel. So, and this is the lighter side. But the point is that these were matters which would have affected the economy at all entirely, and also the impact on this, by the way, involved the heart of the two entities of Tatas, the Tata Trusts and the Tata Sons. Tata is an unusual system where you have operating companies, but operating companies, vast and important as they are ultimately in the hands of Tata Sons, and above that, the Tata Trusts. So this matter went to the very heart of the citadel. So it was important and interesting, and I think it was a great learning experience for me as well.
Okay, point well taken. Before we move on to the next set of corporates that you have represented, I also want to know from you the Singhvi style of arguing. A lot of people in coffee shops across this city and many other cities across the world, they try to mimic. So when people say point number one, point number two, they are mimicking Dr. Singhvi. So in fact, when you also meet lawyers across the city and they try to mimic you, what is this style of arguing that you have developed that a lot of people like to mimic, talk about, discuss, that this is a doctor style of arguing?
Well, first and foremost, let me say that I am assuming, and I think I'm assuming wrongly, that it's a flattering comment, but I'm assuming it. There must be enough vyang or satire in that, and even leg pulling in that. But I'm quite happy that I am a liberal who takes this in stride. Second, I like to say, even if I say it myself, and this was really coined by my friends more than 2 decades ago, that there's a whole new school or Shelley or genre which can be called pointillism. Pointillism. Now, this is on the lighter side, and I'd love to be the inventor of pointillism. But let me tell you one thing, on a more serious side for youngsters who are into advocacy. As they always say, it is easy to be long, lengthy. It is difficult to be brief. That famous sentence of Johnson and Boswell, dear Boswell, he started the letter saying, I sincerely apologize for writing the long letter because I don't have the time to write a short one. So pointillism, for advocacy purposes, it needs precision. It needs clarity. It needs thought out processes. And it needs a Gagar mein Sagar approach. It needs you to be able to encapsulate the issue as briefly and as pointedly as possible. Now, that's not always easy. You can admire it, you can make fun of it, you can praise it, you can criticize it. It sounds repetitive also, because when you do it in many cases, as I do, it sounds repetitive. But then, first and foremost, it helps me personally marshal my thoughts. It forces me to be specific. It forces me not to wander, to, do filibustering. And it forces precision. And I think that's all for that. Ultimately, our judges are so overworked that where they find that I am right in terms of that process, they would also save time. It's a two-way process. It helps me, and it should normally help the judges, otherwise be counterproductive.
One thing that a lot of people talk in the industry is that there are lawyers that you would invite, request to appear for an admission and a notice. There are lawyers that you would want to do final arguments, engage. Dr. Singhvi is a lawyer who's very good at admission, notice, stay, and equally good at final arguments. How has that been possible? A lot of people would like to know how you are equally good at your miscellaneous day and your final arguments. How is that possible?
Senior lawyer put it differently. Since you asked the question, I'm saying it. Please don't think that I am being vain, or because this is a question, and I don't believe in false modesty. He said that this happened when I did back-to-back 6 constitution benches in the recent past. It happened in various matters were coming in court one. So he said it's very interesting that you are a T20 player, a one-day player, and a test match player. So I said, look, you're being too kind to me. I don't think of myself as that. But it was in cricketing analogy, an interesting comment. Now, I don't ascribe any special thing on that, but I think it's important to be aware of the differences of these 3 Shailis. It's also important to realize that you can be a T20, a one-dayer, and a test match. You may not be able to do it in cricket, but in litigation you can be. You can be if you are aware. And awareness, first and foremost, is a must, that the judge, poor fellow, is hearing 60 matters a day, 50 matters a day. So you're doing a T20, you have to have some mercy on him also. On a Tuesday, he's maybe doing a one-dayer. And on a Wednesday, Thursday, he's doing a final hearing, a test match. Now, the way you make your note, after all, even on Mondays and Fridays, very complicated matters come. They are inherently even test match matters. But on the first day, the test match has to be presented like a T20. And that depends on the presentation. So what happens is, Tarun, people who come to brief me are much better versed than I am. Why do they engage me? They are much better versed than me. Some of them are masters of the whole case, fact and law. They do it because I'm able to tell them how to put it in a format for a Monday, Friday. What matters to that judge is the relevant 5 bullets why notice he should issue, or conversely, if Tarun on the respondent side, why he should not issue notice. After that, the other 5 bullets he needs is, if he issues notice, why he should not give stay, or why he should give stay, as the case may be. Now, you should be able to reduce those most complex of cases into those 10 points. Now, the same thing happens on a Tuesday. But since he has a little more time, it's useful to give some flesh and blood to it, because on a Monday, you have succeeded in getting his attention. He's opened the door. He's allowed you to enter, but stand at the edge of the door and given you a date. On the Tuesday, he's likely to dispose it off. So don't try and be as superficial as you were on a Monday. Ultimately, the same principle applies on a Wednesday, Thursday, that you must hold the judge's interest. Let me tell you, as Justice Kaul used to say frequently, if you make it interesting, or even just Chandrachud said it, if you make it interesting, time is never a problem. If you make it relevant, judges put time limits. They're overworked, poor fellows. They're always constantly, under burden. But if they find that there is something which helps them and eases their burden, you have to think how you can present in a 2-pager, how it eases your burden when you go home and you don't have a singvi, or you don't have an opposite counsel arguing. You must sit at home on your own and write a judgment. If you give him a very complicated structure, which is actually fantastic for a LLM thesis, but the poor fellow cannot write a judgment at home, not even for a final hearing. So why do you harass your judges like that?
Point.
Awareness is important. If you are aware of it, then you'll do it correctly.
Point very well taken. Now, moving on to another area of advocacy. When do you do constitution bench cases, and you do quite a lot, some of which we'll discuss in the course of the program. Is your arguing strategy different because it requires long-winded arguments where you're trying to prove a constitutional point, convince? Do you think from commercial matters, when you switch and from court to court, many times you're doing a top commercial matter and then you immediately change stance and are arguing a constitution matter?
Tarun, let me tell you that we have discussed 3 genres in a more lighter vein. We've called them T20, one-dayer, and test. Frankly, a constitution bench is neither of the 3. It's a 4th genre, which doesn't exist in test cricket. It exists in litigation. A constitution bench should be mandatory for everyone at least once in your life as a lawyer, as a litigator. You cannot be a complete litigator till you've done a constitution bench. A genuine constitution bench of the kind we have now, many of them, where the judges are very bright, very on the take, where the Chief Justice gives you enough time, is a great training ground for even all of us who have spent a lifetime in law. Now, how do I distinguish the other 3 categories in constitution bench? A, you require to nuance your argument because you're actually arguing on the frontiers of law. You're not bound by precedent, by narrower considerations as you are in the 3 earlier genres. Even the doctrine of precedent, to the extent it's relatively relaxed, it is only in constitution benches. 2, your creativity can be at the highest. So you can develop an argument saying, this might have been decided, but it's decided by 3 judges. I think this is a better viewpoint for the following reasons. You are 5. You can differ. I just did the 9 judges just now. So 9 ultimately is a tabula rasa. You are painting a new painting. The paint brush is new, the color is new, your style can be new. Now in that course, you have to tell them that already the paints have a 7-judge and a 5-judge and a 3-judge. But at the end of the day, if you, my lords, are convinced by the novelty, the creativity, and the nuance of my argument, then you are actually going to be painting a new picture. So it is really at the frontiers of creativity. You are actually developing law. And I think for that, and there again, let me tell you, to be arguing second in a constitutional bench is much more difficult than arguing first. The opening chap has the advantage of taking whichever direction he likes, howsoever wrong, howsoever right. The second chap has to nuance himself much more to fit in with what is gone and not bore them. Because constitutional bench is also about holding attention. And then you have to be very precise. I've had the privilege, as I said, in the recent past of doing back-to-back, from same sex to 9 judges just 2 weeks ago, 4 weeks ago, the mining matters, that is.
Yes, the mining matters.
A host of arbitration matters like Cox and Kings, to a host of earlier matters. So I think it has been very exciting. And ultimately you argue for 2 days or 1 day. But for that, prior to your argument finishing, you are tense and you're actually having to sit for at least 2-3 days in the court. It's the sitting or hearing or conferencing prior to your 1 day. And that may take 3 to 4 days, which is vital. People tend to think, oh, he's arguing for 2 hours. That 2-hour argument in a constitutional bench requires sitting in the nuances earlier and also preparation of much longer than that 2 hours or that 2 days.
Point well taken. One quick comment from you would be, when you are arguing a constitution bench matter, which you know would decide the course of the country in one way or the other, in taxation matters, the course of entire industries and revenues of the state, like you are arguing the royalty on mining matter, which you just mentioned, does it bear heavily on your mind? You think or ruminate about it a lot because you realize the implication depends on many times on how you're able to convince on the idea that you're propagating to the bench.
I'll be very frank and share an anecdote with you. First answer to your question is no. And I think the hallmark of a good litigator is that you must minimize the weighing on your mind. Now, we are hypocritical to say that it doesn't weigh on the mind. Obviously, every human being, it weighs things weigh on your mind. But now, having spent, nearing like half a decade, half a century in litigation, not quite there yet, but still quite a long time in litigation, I have learned to be a professional lawyer in the sense that I'm not emotionally attached or overwhelmed by the case. And that's very important for a counsel. If you're emotionally overwhelmed by the case, by over-identification with the case, then normally you will not perform well. The one exception to this was a very recent anecdote which I'll share. It's a bit confidential, but I don't mind sharing this. I've now talked about it. When Rahul Gandhi's case came, he had lost in 3 courts. So I telephoned him before the matter came in the Supreme Court. I said, look, I'm a professional litigator. I don't let these things weigh. But in your case, it's weighing on my mind. And the reason it's weighing on my mind is that A, the whole country is waiting. If possible, at least half the country is waiting that Abhishek Singh will fail. Another half of the country is waiting that you should fail. And the consequence is that for a 2-year sentence, maximum for a small offense like defamation, you are out of public life for 8 years. Which means effectively your entire productive political life just weighs on me for nothing. He said a very nice thing. He said, look, I have complete confidence in you. I don't care. You do your best, treat it like any other thing, which means don't let it weigh on you. I think that as a general principle is important. Of course, when unless you have the adrenaline running, as they say, unless you have some degree of cortisol being released, you will not also do your best. So that is natural. But don't get overwhelmed by it. And then it helps, of course, that you've done 42 years of litigation. So it helps a little bit.
One thing I want to ask you before we move on to cases and different cases about corporates is that you have a dual identity. You have a role as a lawmaker 3 times in parliament and many more in future. And also a top lawyer at the Supreme Court of India. You have been involved in lawmaking. You authored the Lokpal report. Your father also had a role in that issue one point of time, the ombudsman, which you shared with me on earlier shows. Since you know this so well, obviously for 21 years in 3 terms, when you have, how are you different than the others when you go through this experience of life? You're in court and you're also making law.
Uh, by the way, I must tell you here, as I said, I think earlier in our program, one day Jetli and I were walking out after a speech in Parliament by Yechuri, who was speaking at length about why accountants, doctors, lawyers, architects, etc., who have to run their profession should not be members of Parliament. So when we came out into the hall, Jetli said to me that Sitaram is apparently saying that not only should Parliament be a group of the unemployed, but also the unemployable. So, thank God that you allow talent to be there in Parliament of a professional kind. That's a general statement, number one, for your question. Number two, I think it's very important to keep the roles separate and yet treat it as an immense learning curve. I have always said that for me, multitasking is the joy of my life. It is also the bane of my life. It was the bane of my life even more so earlier when I used to get very harassed and hassled by not reaching and doing everything on my list, which included public life, press, of course, law, all very, very jealous mistresses. They all require 24/7 service, and they are very jealous and very difficult to satisfy. But over time, I've learned to do what is comfortably doable and not regret what I cannot do. But I've always also labored hard at keeping Chinese walls between. You will notice that in court, I don't mix up politics as far as possible. In politics, I don't mix up court. And normally, in a case where I've appeared on the same day, etc., I never give a statement. The cases I'm speaking on are cases where I either not appeared or the case is over with a judgment. Equally, as a parliamentarian, I enjoy very much the process. You see, it's a learning process. I've said sometimes that in the morning, if you stand and you take an example of doing, say, 7, 8 cases till lunch, you have this particular genre of precision, logic, my lords, volume 1, page 5, at 12. So you have the same thing, which is, very, very logical, precise, cold. You get into the car, change your shirt, and enter Parliament, and maybe you are debating the same bill on the same subject on which you argue the case. The style will be radically different. It will be rhetorical. It will be wide canvas. It is not the more cold logic of volume 1 and page 5. But it's a similar topic. But it's a great learning curve because the way of presentation is totally different. And I've done it many times. I've now had the privilege of opening the debate in Parliament for the benches, both Treasury and opposition, for every major debate from 2006 till 2024. Almost every major debate. So that's another learning curve. A third learning curve is that the same evening you go and do a press conference. There I joke that you have a miniaturization, you have a Nobel Prize for miniaturization. Because people of your tribe want it to be completely encapsulated, what you call Gagar mein Sagar. And again, take it the same theme, which was in the morning in the volume 1, page 5, in the afternoon in the Parliament, and then. So this is, after all, a tremendous learning curve, and you treat it as such. And you be careful not to try and leverage one against the other or mix up the two, because then your credibility suffers.
One thing that I want to ask you, because you do so many commercial cases, and as a professional lawyer, you take up, be it politics or business clients, you take up all cases without being biased towards anybody. As a lawyer, it's your duty to defend the client, and you do it wonderfully. What I want to know from you is that when cases involving, say, contracts with the state are argued, on which the whole investment climate in India hinges upon, and you do those kind of cases, what is the sort of thread that goes through your mind that on my argument, if I do this case well, India will receive thousands and lakhs of crores of investment, because you as a lawmaker would be working on something like PPP or those kind of things there, and there you're arguing, when in a country like India, private sector is constantly it lands up in legal troubles due to various states, issues at the local, unforeseen issues, land issues. There are so many issues that crop up in a country like India. If you could take us through that thread.
No, there you have to be a little nuanced, Tarun. There is, in that sense, a conflict always between different sectors. And it is futile to wish it away. Number one, the common law system in which the litigator like me argues is obviously a narrower system. It depends on the dialectics of adversarial arguments. And the concept is that let the truth emerge out of the series of thesis, antithesis, and then synthesis. So I say black, Tarun Nangia says white, the judge decides gray or white or black as the case may be. That has to be a narrower approach by the very structure of way it is structured. Number two, lawyers don't judge their clients, should not. They also don't choose their clients. Do I choose that you will come to me, or that somebody else who is not as tainted as you will come to me, or a third person who is the worst tainted to both of you will come to me? You can't choose, you don't choose. So you have to make the best of what is there. Now, it is true that in some matters you take the stand of the client which you are representing, your success can become an enemy. What happened in the person's case who argued that sawmills long ago in the arbitration field? The saw pipes judgment was criticized for a long time. For that matter, even Bhatia in arbitration was criticized for a long time, but some counsels succeeded and the judges accepted it. Now, it was criticized because it was felt to be anti-arbitration and, as you put it, anti-investment. People who would come would be more hesitant. But then, can the lawyer who argued Bhatia or saw pipes say that, look, I am concerned about investment, so I'll ditch my client's case or I'll spoil it? He has to do the brief. There is an inherent conflict. When the same lawyer sits as a parliamentarian, he's not bound by what he has argued. He will look at the bill and he will look at things. He's not going to say that, look, I'm going to make an anti-arbitration clause in the bill coming up because I believe that I won the Bhatia case years ago and that thing should be. So these are reconcilable conflicts, but the conflict has to be realized. And the canvas is very different.
Point well taken. Now let us count a few cases on the commercial side that have been big successes and you have had the opportunity to represent. The first we discussed at the onset of the show was Ratan Tata, Tata Sons, Tata Trust, who you represented in the Tata Cyrus Mistry case. Which are a few others that you would, notables that you would like to share with the viewers?
Well, commercial cases we are doing every day, there's no end to it. I mean, frankly, cases, for example, this is again invidious to select, but you're asking, just thought comes on a more recent case. A very interesting case where I must admire the approach of the Honorable Chief Justice, who was then senior most judge, not the Chief Justice. The current Chief Justice sitting in court too. And this case, I forget the name, it came on banking frauds. And the passages and the facts were published, very famous cases used everywhere now. I think it's Rajesh something. Now, that case involved very dirty facts. It involved bank fraudsters. It involved people who were declared not NPAs, but fraud. Now, the issue was, can you go to the declaration of fraud before giving them adequate natural justice? Now, here was the state, the RBI opposing us, and more than the RBI, the banks opposing us, law officers, including Solicitor General downwards appearing, saying that, look, where is this question of natural justice, this great equity of ethic of natural justice to such fraudsters?
This guy Rajesh Kumar versus SBI, I guess.
That's right. Now, that kind of case has remarkable commercial implications. And as a whole batch, I led the arguments. And I must say the learned judges went into the finer nuances of public law. They said the most important role played by natural justice is when it is under threat from bad facts. Bad facts should not allow to make hard law. And they upheld the principle ultimately, and we won a thumping victory, which has cascading effect down thousands of cases in the country.
Yes.
Purely commercial. That the process of declaration of NPA is different. The process of declaration of fraud should be different. And though it is, the argument was that before I send an FIR against you, I don't have to give you natural justice. The court debunked that argument. It says before filing an FIR, you don't have to give me natural justice. It doesn't mean that before declaring me a fraud account, you should not hear me. Hear my point of view. The effect of a fraud account is that the whole world ostracizes you for debt. You become a completely de facto bankrupt without being a de jure bankrupt, because no funds are forthcoming. So natural justice is important. And please don't give the analogy of an FIR. One argument in one sense was that, look, fraud and FIR are similar. But they said no. So these are the interstices of commercial law, which are interesting.
No, but Rajesh Kumar, SBI, all industrialists talk about. I did a show on the same. And all top industries, even small businessmen, people, I was taken, everyone speaks about this case.
Yes.
So we spoke about the Ratan Tata case, we spoke about Rajesh Kumar versus SBI, which is the one more case or which we would like to share.
There is a interesting commercial case with constitutional overtones, which I can share early in my career, because the story behind the story is more interesting than the case. That is what is called Tata Yellow Pages or commercial free speech case.
Commercial free speech.
So it was a strange intersection of commerce and commercial matter with constitutional. Tata Yellow Pages was there. The government of India had some silly rule under the telecom rules which said that you can't have this size, that size, you can't do this, that in the Yellow Pages. Those were pre-internet days. Yellow Pages was the main way of advertising. The argument was raised on the interpretation of that rule in the High Court and lost. When we were coming to Supreme Court, my good friend, very, very competent lawyer in Bombay, S.P. Chinoy, and me walking in the corridor of the Supreme Court discussed, and we came to the conclusion that let's also file, along with the SLP against that matter, a writ petition Direct 32, saying that commercial free speech, apart from interpreting that rule, that silly MTLL rule of, I remember the rule also, 454, you must also say that this is commercial free speech, Yellow Pages, and commercial free speech is part of 19(1)(a). That is free speech. Now, when we went to the Supreme Court, we discussed and we found that there is a direct Supreme Court judgment called Hamdard, which said that in America, it has been held that commercial free speech is not part of free speech because it's commercial. And they said, we have followed in Hamdard years ago this American judgment. I was before a very feisty bench, so I decided to take a chance. I argued that, look, in the country of its origin, America, that US judgment has been overruled by subsequent US Supreme Court judgment, which has held that commercial free speech is no less free speech just because it's commercial in nature. The Supreme Court went to the extent of distinguishing and not applying Hamdard, its own larger bench case, because they were persuaded that in the changed circumstances after decades, India was not hidebound to be tied to the coattails of a US Supreme Court judgment given decades ago. And they held in this thumping judgment that commercial free speech is as much entitled to all the protective arcs and safeguards as normal free speech under 19. So this is a very remarkably important case for commerce, but with free speech constitutional intersections.
Point, very well taken. One more case on the commercial side. We discussed three, Rajesh Kumar, SBI, Tata.
You have to prompt me. I can't remember now. I'm pretty bad at remembering these things. Commercial case. Well, I would say this recent constitution bench on mining.
Oh, this is all of commerce. I mean, this is thousands for all the states.
This is the reason why it's easy to deal with it. I just finished arguing it hardly 3 weeks ago, 4 weeks ago. Judgment is reserved. But again, it is the frontiers. It was at the frontiers. For example, I raised the issues which are not raised by the others. A, is royalty a tax at all? We said you can call it by any number of names. It is. Second question, these were all nuances. And on our side, different people took different stands. Now, this has got, in terms of numbers, in terms of the zeros and the, quantum of money, this was the highest value case because the states want collection. Then we also discussed the larger issues of federalism, the interpretation of that particular list 1 of the central government. Very interesting nuances of list 2. What it means. Did you carve out only a limited area for the state or you carved out the whole thing? So I think this was another intersection which is called constitutional, of course. It is constitutional. That's why I went to 9 judges. But it has huge commercial implications. And let me tell you, the center, this is a strange case where all the private parties, the public sector companies, and the central government were one side together. And the states were opposing. So the figures of commercial were very interesting. They said that though the figures are gigantic, and though the trillions of rupees are collected by the center, 90% of that is paid back to the states through the Finance Commission devolutions, etc. So your lordship should not think that by holding in favor of the center or the private parties on our side, your lordship will be depriving the state governments of revenue. So it was a mix of both practical commerce, practical figures, and constitutional interpretation, of course.
One thing that I would want to know from you, and here your intersection as a parliamentarian and as a senior lawyer, top commercial lawyer comes in. You make a law, but if that law leads to a lot of litigation, when you end up in court, for example, the liquor prohibition law in Bihar being one thing, or the twin conditions for bail, which now every bail case goes up to the Supreme Court. I mean, you can't be complaining as a lawyer because you do all the top litigation. But on the one side, the twin conditions have for bail in PMLA. That is what I'm speaking about. That led to a lot of bail litigation right up to the Supreme Court. In fact, the Chief Justice himself lamented that the the district judiciary has not been giving bails also. How does this play in your mind? Okay, we made this bad law, and the whole courts have the judges are.
I have, Tarun, you raised an important question. I've spoken about this more than 20 years. It's on record. Prior to, I don't know which year, about 40, 50 years ago, at least the early time of our republic, we did not even have in the bill at the end a financial impact memorandum. You know, you did not always say that, look, this financial impact of this legislation will be XYZ. Luckily, that started several decades ago, and every bill I receive as a parliamentarian has a financial impact memorandum. I hope I'm clear. Now, the short point is, why on earth for the last 20, 30, 40 years do we not have a judicial impact memorandum at the end, or what I call a litigation impact memorandum? It's very simple. Today, do you know, in Parliament we are discussing, we come full circle, because the two biggest cloggers, the arteries of the heart are clogged and you do bypass surgery. The two biggest cloggers of the litigation artery are 138 so-called check bouncing cases and 498A so-called dowry or anti-dowry cases. Now, when we passed the legislation decades ago, nobody had an idea that in quantitative terms it will be lakhs. Now, they may be good, it may be required, but then we realized, is it really required? Because now 138A cases are taking years. So did you so intend it when you created the reform? Now, had you done a judicial impact, what I call litigation impact assessment, which I believe should be mandatory. So it's very easy to pass a law. I pass a farman, I say, I am the legislator, I pass a law. Before I pass a law, do you count the amount of litigation to generate? Supreme Court has now gone on record. Chief Justice and Justice Gawai have said so several times. The litigation impact of prohibition in Bihar, the entire, you see, in a high court, practically only one or maximum two judges sit in this roster. So any case of prohibition involving thousands of arrests or thousands of notices will go to that one or two posts. In a particular state, I think it was Bihar, the first listing of this matter would take 2 months. So you are in jail, the bail would not be listed. Forget getting bail, forget arguing bail. It will not be listed for 2 months. Now, you never realize the litigation impact of this. So every bill, small or big, should have a litigation impact memorandum, which should be a broad assessment that, look, we are passing a litigation. This litigation will impact sections A, B, C, D, Z. Obviously, nobody is saying it's a prediction. Nobody is saying it's accurate. Broadly, we believe the past trends are so much. The future trends will give this relief. We believe it will lead to 10,000 cases per year.
This question that I'm wanting to ask you is that you did your PhD thesis at Cambridge that involved thousands of pages of writing. So deep work is something that you were used to when you entered the profession already. When you see in Parliament that without discussion at all bills are passed, do you sometimes sense while sitting on that chair that, oh, this is going to lead to a lot of unnecessary litigation? We have not read it enough. We've not drafted it carefully. We've just rushed through the proceedings. This is not what Parliament is meant for. There should be a lot of active debate and discussion that we have had in Parliament, even earlier in Indian Parliament. But these days, everything is rushed through. Do you think this rushing bodes well for the judiciary? Why? Because the Parliament can rush it. The judiciary can't rush anything. It has to go through the details.
I don't think anybody will dispute what you are saying. I have had family members in parliament in the 60s. I myself spent 18 long years in parliament. There's a sea change even during my time. There are various facets of it. Point number one is that the quality of draftsmanship in the ministries, you have to accept, is abysmally different than when, the old guys, some of the top people you heard of, I won't name them, they are top draftsmen who used to do secretarial jobs in the ministry, like secretary law, etc. Top draftsmen. B. Sen used to draft treaties. The precision, that talent is gone. Point one. Point two, the whole political arena is divided. It's a fractured mandate. You do not have consensus for ordinary statutes. What to talk of a consensus for two-thirds amendment to the Constitution? Now, when you have a fractured mandate, then you are scoring a debating point over the other. You are not having a nuanced, convergence, cooperative approach. It happens like once in a year in a rare bill, but 99% it won't happen. It's a fractured mandate. Number three, on top of that, politics takes a further ugly turn because, for a variety of reasons, political mostly, the presiding officer, I don't mean the actual presiding officer, whoever is presiding in the chair, doesn't give enough time. Your political color may not suit my political color. You will get more time, I'll get less time. Fourthly, parties themselves, the parties allocated, let us say, a total of 100 minutes. They themselves decide who will speak. Intra-party also politics takes over. The most inappropriate person to speak on legal journalism is Abhishek Singhvi. He'll be given the slot because he has a political clout in his party. The most inappropriate person to speak on toys, Tarun Nangia, will be given the slot for toys because you have a different kind of clout. Now, you don't use your talent the most judicious manner you should. This is the fourth reason. Fifth is that the majority system, which must change, means that the government moves the bill. The government rarely changes it. There are some amendments which by consensus can go, but broadly, the bill is meant for discussion with very little scope for changes. There are hardly now examples where after a debate of 2 days, where I'm assuming the debate is not politicized, I'm assuming it is not fractured, I'm assuming it is not disrupted. That's the fifth reason, by the way, disruptions. Worst is you walk out. You don't get my input at all. Next is that the other side gives you no time or they outshout you. You don't get my input at all. But then the last point is that the government of the day has to be open that these are suggestions coming from disinterested speakers. Let's make a change. That sentiment is gone. So these 6 reasons coalesce and combine to make parliamentary drafting much poorer than it is. It makes judges struggle much more than they used to. And ultimately, it's anti-public interest because you have observed results by observed drafting. Take a simple example. That provision of the Arbitration Act, which was not fully drafted, led people for years to interpret it to mean that the filing of a Section 34 challenge to an award meant an automatic stay. Did any parliamentarian apply his mind to it? Did the draftsman apply his mind to it? And for that matter, did the court think of the consequences that you are actually encouraging a challenge to an award because by filing a challenge, not getting a stay, by filing a challenge automatically, if the award is against Tarun Nangia for 1 million rupees, Tarun Nangia gets an automatic stay. That went on for years till 2015 we amended it. And it took a further number of years till the 2015 amendment was self-interpreted.
Now, moving to this arena of you've represented politicians and commercial leading figures, leaders of the industry in equal measure. Uh, can we count a few people? Of course, there are hundreds, so both commercial and politicians. We can't count in a breath, but a few interesting ones if we can count that you represented.
I think, frankly, it's invidious, but as I said, I have the privilege and the pleasure of representing every part of the political spectrum. Since it's public knowledge, I have no problem taking names, but it's not necessary. There is Mamata Banerjee of the TMC, Abhishek Banerjee, Mr. Stalin, his son, Mr. Udayanidhi. I'm talking of recent cases, in the last 1 year alone.
Yes.
Uddhav Thackeray, Hemant Soren, Kavita, K. Kavita of Telangana. Of course, the entire gamut of AP, Arvind Kejriwal, Manish Sisodia, Sanjay Singh, Satyendra Jain. Punjab, numerous leaders. Chandrababu Naidu. Interestingly, Chandrababu Naidu has also Jagan Reddy, but not personally. Jagan Reddy's matters generally. Kamal Nath, Bhagwant Mann,
Bhupinder Hooda.
Bhupinder Hooda. I mean, as I said, it's a matter of some satisfaction that they have reposed confidence, and I have done it with a certain amount of, uh, transparency and imandari, because I don't mix, I don't carry tails here to there. And
Siddaramaiah.
no, D.K. Shiv Kumar, Siddaramaiah, no particular, also him, but I mean, he's not really much into
And
litigation.
Rahul Gandhi, Sonia Gandhi, of course. So
that, of course. So it's across the political spectrum.
Well, one thing I want to know from you, I just
Sharad
Pawar. So I saw most recently Sanjay Singh in his press conference publicly thanking you of representing his case, and he came out of jail, and he was thanking you for the way you put forward the arguments and his points for the liberty of the individual. How does it feel when these kind of reactions come?
No, I think that's his magnanimity. It's his Bharatpan, and I think I really appreciate it. I thank him for it. It's good to know that you're remembered. It's good to know that people realize that. And I think you do it with you don't do these things with that expectation that Tarun Nangia will go on a channel and say that, but you do it with a quiet satisfaction that you've done your best, and then somebody's noticed it. I think it's ultimately the large-heartedness and the magnanimity of the person who said it.
Talking about commercial litigation, Tata was, of course, the case that we discussed when we started the show. Can we discuss one or two other commercial cases which interested you over the years? It can be anywhere from 91 to today.
You are obsessed with commercial cases, huh? I've done 4 with you already. What else? You have to jog my memory.
Anything that you can remember. I mean, you do 18 daily in court, so I know it's a challenge to remember.
Commercial cases. Well, a very interesting set of commercial cases I've done. Yeah. Across all high courts, by the way. I've argued and succeeded in Tamil Nadu High Court, that is Madras, in Karnataka High Court, that is Bangalore, at Kerala, and also in Andhra Pradesh, I've argued it. Now it's in the Supreme Court, awaiting final judgment. Is this whole thing about game of skill, game of chance?
Yes.
That has huge commercial repercussions. And now it is added because of the GST and the taxation on it. That's a separate facet. But the game of skill line of cases which I've succeeded in directly are the Karnataka Chennai batch, which are now reached the Supreme Court. Again, they have all, remember, a lot of so-called commercial cases have a lot of constitutional intersections. So it starts with the whole concept of a game of skill. I was doing specifically the rummy batch, which is a huge number, and you'll be surprised how many people out there play. And I'm talking about online rummy. In the old days, you've done physical rummy. Now it's much more online. And therefore, that raises a lot of interesting issues about from Chamar Bogwala. What is a game of skill? What is a game of chance? If it's a game of skill, does it have to be 100% a game of skill? Obviously not. For example, when I give out the cards in a deck in rummy, the giving out is a matter of chance. Whether the Tarun Nangia gets an A and I get a B is a matter of chance. But that doesn't make it a game of chance. It remains a game of skill. Chess. But equally, teen patti, poker. Poker may be a game of skill, but teen patti may not. So it has a very interesting line of cases. Horse racing. And then you apply it to constitutional law, that why did our framers intend not to treat game of skill and game of chance the same? They gave one power to the state, game of chance. They gave one power only to the center. And a game of skill cannot be dealt with in the same penal manner. It also can be dealt the same way in a commercial manner as a game of chance. Because the idea is that you are not here to prohibit and stifle games of skill. So this is another very fascinating line, and it's all across the country. Today, online gaming. Now, by the way, the word gaming is very misleading. It includes both games of skill and games of chance. But online gaming in a generic sense is one of the biggest commercial industries in the country. The figures are in trillions.
One last two questions. Uh, Enforcement of contracts, India has to improve its march. If contracts in India can be enforced, even that those people enter with the government, then investment will flow into India. But also for investment to flow, the enforcement of contract rates have to go up. The courts have to uphold these contracts. Uh, because you have an experience as a lawmaker and a top lawyer, how do you see India progressing on both these counts of enforcement of contracts, enforcement of arbitral awards also as a subset, because in the end that's out of commercial transactions, and also both of these things?
In a summary answer, one, we are far better on in 2024 than we were in 2000. We were far better off in 2024 than we were in 1980, 1970, 50. Far better, far better. Second, we are still abysmally behind if you go for enforcement paradigms in countries like Singapore, Hong Kong, or even for that matter, France and England. England is, by the way, relatively more lax and more liberal about hearing, but even there, it is far superior in India. So it's a question of how, you draw a bigger line or a smaller line. You have to see it in relative terms. We are moving. Courts are conscious. They're not interfering as easily in arbitral awards. But it's an evolving, paradigm. To think that it's a full stop or a dot is wrong. We have, as they rightly put, as Robert Frost rightly put it, we have walked many miles, but there are many, many more miles to walk before we sleep. Many, many more. If you want to be truly part of the third biggest economy, which we are promising to be shortly, if you really want to be part of the global integrated economy, I would say Robert Frost is closer to the truth than the miles you already walked.
Point well taken. One last question. There is a public talk, image, perception about you, about being a lot of hard work that you put in day after day, and the kind of deep reading that you do, that is discussed by all. Methodical is also what a lot of people say. If there is one comment or giveaway that you want to give to so many people who will watch this show, is that after putting in decades of hard work, what propels you to get up every morning, put on your boots and get on the job? Oh, what is that motivation?
Of course, it's not so difficult to understand. First rule, there are many substitutes to top places like Harvard. There is no substitute to hard work. Get it into your head, young, middle, or old. Second, litigator especially. By litigation, I mean the person who stands up and argues, whether he's a junior lawyer, middle lawyer, assisting lawyer, or a senior lawyer. It's a non-delegable task. I can't get up and say, I'm standing before your lordship, Tarun Nangia will argue it now. Now, if it is non-delegable, then what is the substitute alternative to hard work? The previous night, you can't sit and have a drink while your junior is preparing everything and say, "Tum kar lena, argue, main khada hu tumhare saath." So, if that is it's unlike corporate lawyering. It's unlike in-house lawyering, where you can delegate a lot of things. That's number two. Number three, which is overriding both. Ultimately, you cannot do well beyond a point in something you don't enjoy. Law has been my first love. But you have to like public life also. You have to like press dealings. You have to like academic work. I used to be an academic. It's a quirk of fate being the only male child amongst three brothers that I came back. Otherwise, had I stayed even 6 months more, I started teaching in Cambridge. I would never have come back. So I do keep my vicarious foot in by doing academic things in between. I write articles. I did a blitzkrieg of a whirlwind tour to US, and I really enjoyed it. It was a killer. But I enjoyed speaking at Harvard, at Columbia, at New York, at Seattle, at San Francisco, Berkeley, etc., etc. So that has to come from within. There is no, for that matter, I love movies. At the end of the day, my relaxation is to put on some action thriller, which completely switches off my mind from all the paperwork I've done the day. So these are all things you have to enjoy what you like and do. Otherwise, you will not be able to do it. If you try and be me, because I like ABC, therefore Tarun Nangia should like ABC, and I try to be like you because you like XYZ, I should. That won't work. At the end of the day, and also I think as you grow older, you must cultivate the ethic that what you can do well, enjoy it. What you can't do, don't regret. That I still have a problem with because I'm doing so many multitaskings that I start regretting what I could not reach, could not do. But that's part of life.
Dr. Singhvi, it was indeed a pleasure talking to you today. Longish conversation. You were, in a sense, very generous with the anecdotes, with your style of arguing, with commentary on Parliament and outside in the courts. And I think one of the best episodes I shot with you after your biography. Thank you so much for your time. And looking forward to record with you more in future and more cases that you would do at the Supreme Court and other forums. Thank you so very much.
Thank you very much, Tarun. It's always been a pleasure and I've enjoyed it. Thank you so much.